Good evening, everybody. What's going on? I think we're live. I think we're live. You're 5 minutes late, but it happens sometimes. It happens. It's like all hell broke loose when it was time to go live. My name is Nate the Lawyer. Just wanted to say hello to everybody before we start. At Nate the Lawyer. I love the civil laws analysis this morning. Chauvin, third degree murder charge. Yeah, I did watch that too. Shows you I got a lot of free time because civil law does some really great work. But I told you guys he's a deep diver. That guy goes into the deep stuff. So if you want to watch, if you want to really get the full flavor of what's going on, you definitely got to check out his channel. And you got to check out my girl, Legal Bites. She's got, it's some really interesting stuff there. So, but I'm gonna bring them both on right now. First, my brother from another mother. I'm civil law.
So
as we can tell, our complexions are a little darker. You know what I'm saying? I was left out in the sun a little bit longer, but we're all good.
some strange things have happened. There was a fairly famous case of fraternal twins that one came out. They came out looking very different. I think they both they the same parents, but one they don't look anything alike.
Well, it's funny. It's like my kids,
two girls.
Yeah. And Legal Bites, how are you doing?
Hi.
It's been a week since we've all gotten together. What's been going on?
I'm doing well. Just trying to keep up with everybody's stuff and keeping up with the trial. Of course, it's been. I mean, obviously, it moved kind of quickly to a verdict, but I was trying to figure out exactly when that was going to happen. But I mean, yeah, it was fast.
So since I think we have a lot to go over today, right? We have the Columbus thing that happened while me and Uncivil Law are sitting there watching the verdict come out. We got the shooting right down the block. Well, it's actually the state, but then we had that shooting going on at that same time. So, You know what? Do we want to tackle the new shooting first, or do we want to tackle the old? No, that's just the old shooting, but the George Floyd thing first. What do you guys think?
I think both are fine, but I think it provides a nice juxtaposition to discuss both because it goes to show how when you're judging these things, it's very fact dependent. And so you can see, and one of the things I notice in our chats that we've had and live streams that we've had is people have a tendency to take a particular conclusion and try to run it to the ends, runs it to the ends of the page like it's going to apply in all the situations. So like, well, this applies in this situation, so it applies in all the situations. So you'll see chats, and I'm obviously making up this particular example, but this is an exemplar of what I've seen. Because Chauvin's use of force was improper, therefore cops will no longer be allowed to touch suspects. You see that kind of thing where it's like you take this thing that you've learned and you extrapolate it out. And the law isn't like that. It's you have to look at a more complex picture. But I think there's a tendency to be a little bit reductive. So one of the nice things about these two situations is it's the same community. It's an officer involved shooting, and the situation, the fact picture is very different. So hopefully it'll be a nice example of how these things manifest as a legal analysis.
Yeah, one obviously the big issue with one is that the person was trying to stab someone. So since we're going to jump into that, let me get a quick clip here because I thought I had one.
Or appeared to be because it was a nail file or something. I don't know.
We're gonna look at some pictures right now to see if this nail file is if it looks like a nail file if you're a cop. So
the picture didn't look like it to me.
All right, so I'm gonna share this screen real quick. New member, hey, what's up, Sarah? Thanks for becoming a new member. Sorry about the tech issues, but I had to restart
and Legal
my whole
Bites,
computer.
by the way, you have got to interrupt me more because I always feel bad after the fact. I always feel like I'm talking over you, and I always feel bad.
No, it's fine. I enjoy hearing your analysis, so
I just want to share my time nicely with others.
All right, so we can all see. So this is what the cop came to, right? There's a lot more. There's a whole video, but I can't play the video because the YouTube, if you watch my video from earlier where I actually broke this down like step by step, they use like 5 or 6 warnings before you get to that video. So I'm not doing that again. But here, this is what the cop walks up to. He's got a call. First, there was I think about 4:30. There was a call of someone trying to stab someone else with a knife. The cop gets there, and this is what he sees. This woman, pull her arm back with something in her hand, looks kind of sharp to me, and she's lunging and trying to essentially stab this other woman in the paint. The cop, when he sees her move towards to stab her, he shoots her 4 times and kills her. So now, obviously, LeBron James.
Just out of raw curiosity, has the girl in pink made any public statement after this fact about what she has to say about all this?
No.
Whether or not she is grateful about the police shooting this person or not? Does she want to offer an opinion?
No.
Okay,
Nobody's seen it. Now, most people, if you watch the video, it's very quick. It takes about 5 seconds. The cop gets out. He says, what's going on? This girl comes out. She pushes another person, and then she gets into this position. Now, I would say this. If we're stopping the tape right here, if you're a cop and the cop had his gun out, do you shoot this woman?
It would be a reasonable course of action. I don't know if I would, but it would be a reasonable thing to do.
Or do you let it, I don't know, this person's going for a stab.
Let me put it more strongly. I should. But that's one of the reasons that I'm not a cop, because I don't know if I necessarily could do that or not. So it's one of the reasons I don't have the job, Nate.
Well, obviously this video obviously saved this cop's job because this was all coming down as someone who just shot another unarmed black person, but obviously this person has a knife, so forth. So at the end of the day, this is being compared to the LeBron James put out a tweet comparing this cop in this situation to George Floyd, and that obviously became a big hoopla. So I tweeted out to Viva, and then he removed the tweet. But now, this is something that I've always been saying, especially when you're covering these police shootings. Not all police shootings are the same. I think Kurt was saying it earlier about how people want to take one bad thing and then try to make all police shootings the same. This woman is not George Floyd. This is not George Floyd with this in her hand. You know what I'm saying? That's a whole different situation. This is something where if you don't want the cops, this is saying we don't want police. You don't send. What do they call it? They call it a crisis intervention specialist.
Yeah, let's
You're not sending
see how that's going to work.
Yeah, we don't send a social worker to something like this. This is a violent assault. The woman in pink, she looks to be in distress. So how do you guys feel about this stuff? Do you think this is a little overkill, or do you think this cop? Like, I honestly am going to say it. This cop would be a hero cop if these were white people, right? If these were white people, this cop would probably be a hero cop because he's stopping someone from getting stabbed. But now in this day's time, he's worried about his job. How do you guys feel about it?
Well, my impression is, again, I haven't seen the entire clip. I'm just looking at this frame right here. But based on this frame right here, I would say that as a default matter, the police have the ability to use force where a normal individual wouldn't, right? And it has to be reasonable force, but they are allowed to use force where somebody else normally can't. However, if this were a situation that it wasn't a police officer, there is the ability for somebody to use not just self-defense, but defense of others. So even if he wasn't an officer and he had a reasonable belief that somebody else was in immediate danger, that their life was in immediate danger, he can potentially use lethal force, even if he's not a police officer. So that's what I'm thinking about here. So but again, this image is all that I'm looking at right now. So just based off of that, that's what I'm thinking.
Yeah, I feel bad because I should have sent you. I assumed this was like a big story today, so I assumed.
Yeah, when you said that, it reminded me of first of all, you're 100% right in terms of defense of others. If this was not a cop, but just a person with a concealed carry license or open carrying or whatever, lawfully carrying, we'll make it easier. Lawfully carrying. And you saw the situation, you could act in defense of others. Oh, and it reminds me of a very particular situation from a couple years back, where there was, I think it was an armed robbery in progress in a drugstore. I want to say it was a CVS, and a concealed carry holder was walking along the street outside and saw this like happening in progress. So we went into the store, intervened, shot the bad guys. Bad guys are dead. And then I think it was the mother or the aunt or someone in relation to these miscreants who then went on TV and said, "Why did you have to go in the store? They were just trying to rob. He wasn't involved. Why did he enter?" I'm like, I don't know what to tell you. It's like, what? It's like they were committing, I think it was armed robbery at the time too. It's like, this isn't fair. I'm like, yeah. So that's what it reminds me of.
Well, I found a censored clip, so.
Okay.
Hopefully this won't don't get me in too much trouble. So here it is. Again, For those of you, who need a warning, obviously, blah, 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 blah. Be warned.
What's going on? What's going on? Hey, get down! Get down!
So I'm going to stop it here. But this is when she is about to stab the other girl.
First of all, that's a tough shot. I just want to say, because you got those two people in proximity.
Yes. It's a marksman shot. That's a good shot. But he tagged her 4 times.
Did he really?
Yeah.
How many shots did he fire?
4. 4 out of 4.
He hit her all 4 times?
4 times to their mouth.
This is the most accurate police officer ever.
I don't want to laugh, but yeah, it was.
The police are not exactly well known for their accuracy. Reminding again of another incident. I remember an incident where it was initially reported as an active shooter incident in New York City, and it wasn't an active shooter. It was the police chasing the guy who shot him. I think 23 bullets. How many times did they hit him out of the 23? Do you remember, Nate?
I don't think they hit him at all, right?
Oh, yeah, 0 would be the right number.
Sounds like stormtrooper level.
Yeah. So
that was, but they shot like everybody around. Like
yeah. So 4 for 4 is pretty damn good, especially when the people are at that distance. The fact that he didn't hit the victim is amazing.
Cop was an ex-military marksman,
apparently.
So he tags her 4 times. So you guys get a little more context. So that's what happened, and there were marches in the streets, right? They started, hell no, we won't go. Say her name, that type of stuff. But now, obviously, people know that this cop. This is a different than George Floyd. So go ahead, what you were saying?
It's a very different situation. Clearly, I mean, it's number one. It's very fast paced. Whereas with George Floyd, that was like 9 minutes and 29 seconds. They had at least 10 minutes. That was that the incident was going on. It actually was a lot more than that, because the 9 minutes and 29 seconds was how long he had his knee on his neck. The incident was much longer before that point, when they were trying to get him in the car, et cetera, et cetera. So there was a lot more time to sort of analyze the situation and figure out what sort of actions that they should be taking. So this is a much faster situation, and it looks like it's like instantly aggressive, that he had to make a very, very quick decision as to what to do for the safety of others. And I think, I definitely think that this is a very different situation.
But now it's I think we've gotten to the point where how can police, if this cop can't stop this stabbing, then what do people believe that police are supposed to do in these particular situations?
Well, it's just the Blake situation all again, because Blake was, it's very comparable, because Blake was there either in the act of committing assault at the time. Either way, he had a restraining order against him. And the police were called there by a black person to protect them with a lawful restraining order, and I believe an assault that was actually in progress at the time. Yeah, and so it's like, so they're both similar in that a black person is calling the police to stop another black person from committing violence on them. The police intervene in a lawful way. They shoot the people in both situations, and in both situations, the immediate reaction is one of outrage, which strikes me as odd, because what's the conclusion here that we want to draw? If we're upset about this, what is the new rule? And it's because it's one of the things that's like, what is the new rule? So it's like, if we're unhappy with this rule, then like, okay, what's the new rule? The police shouldn't respond to this. They shouldn't, enforce these orders. They shouldn't. They should only send crisis management teams, including when someone has a knife in hand or nail file in hand, as the case may be.
And this call was for a knife, though. It's like they called the police saying there's somebody with a knife, trying to stab. So now, if somebody's holding a nail file, how does that cop know this is a nail file versus a knife? He just got a call saying this is a knife. You know what I mean?
Yeah.
Right. That's even more evidence for the reasonableness of his action, because he's going into it thinking that there's a knife. He sees something that looks like a knife, and he takes action.
Yeah. Now it could be it. Now that's some people saying, why didn't they hit him with a taser? Why didn't they hit him with the pepper spray? And I like to tell people this is that you're stopping a threat. There's nowhere in the United States where they say if somebody pulls a knife on you as a police officer, you pull out your pepper spray. No, you always want to stay one level above the person, because you want to overcome that force. This is not, police don't fight fair, right? If somebody says, throws up their hands and throw up the dukes, we don't, just, all right, we're going to do it, old style. You take out your pager, you take out your pepper spray, you try to get more officers than suspects. you try not to fight fear because you don't want anybody to get hurt. So people who believe that police could respond to this with a taser don't understand that. Look at Jacob Blake. Jacob Blake was tased like 4 times, and nothing happened to him.
That's right.
You know, so the reason why you're using a firearm is because that was deadly physical force. Holding something that looks like a knife to somebody and lunging at them, that's deadly physical force. That's serious physical injury that could be held. And to respond to that, you need to stop that threat immediately so the other person doesn't get hit. You know, do you let them take a couple of stabs before you say, oh, well, the taser's not working, let me now pull out my firearm? It just doesn't work that way. You know, you're trying to stop the threat. Go ahead. I'm sorry. I'm monologuing again.
No, you're exactly right.
But so now, if you guys, because I know everybody's probably like, all right, you know, I think we're all in agreement with that case, right? That's like, it's done, right? There's really no more to talk about,
right?
So let's get to
there's one more point that's worthy of talking about. The initial reports, including from the family in the immediate aftermath of that shooting. If memory serves correctly, I believe it was again like the aunt or something who said that the knife had already been dropped well before the incident, and made it seem like this was completely wrong. So in this situation, the eyewitness testimony was belied by the body camera footage. It's kind of the exact opposite of George Floyd, because the initial report from George Floyd was the death was due to a medical incident. That was the initial thing that the Minneapolis police went out with as their initial press release, and then the body cam belied that. But it's interesting just how wrong the initial story was. So
for George Floyd,
right,
in both situations.
And that's why I didn't until 20 minutes ago or whatever, I didn't actually know all that other information about the nail file or the knife or whatever, and I just knew basically from the headline of what had happened or what people had said had happened, and so I hadn't looked into it as quickly as I otherwise would have, but I don't know.
Somebody, Joseph, is saying, why don't we shoot the wound? Right, fine, just make that. But people think that this is the movies, right? That you can shoot somebody in the leg, which could be even more dangerous to shoot in the mask. Yeah. Like, people don't understand.
Or Joe Biden or someone with that.
Yeah, shoot him in the foot. People, listen. Police, as Kurt was saying, we're not marksmen, right? We're shooting to stop the threat. You shoot to stop the threat. You line up everything. You try to shoot to stop the threat. It's like, you're not shooting somebody because that bullet can go somewhere and ricochet, right? The reason why they train you to actually shoot in a mass is because they're trying to also limit those bullets going wild and going to other places, like in the Breonna Taylor, for instance. Remember, 4 bullets went through the wall and things of that nature. So
I used to be a semi-competitive pistol shooter. I'm out of practice these days, but I used to compete at Quantico because they were nice enough to let us borrow their range, which was really cool. Anyways,
nice.
Yeah, it was really cool. Anyways, but I used to be semi serious about it, and even when I was at my heyday, I couldn't hit like the arm or leg of a moving target on the fly. It's like it's just not possible, because you have to add in, the fact that you're moving and your body is moving and your adrenaline, your heartbeat is going, and then be able to hit a target that itself is moving, and you're looking at a smaller mass. It's like, now that being said, I mean, I wasn't one of the best. I was about average in that competition because I was only semi-serious. So I was about middle of the pack. But that being said, I couldn't hit that on a reliable basis. So, and I was much more qualified than a police officer at that point. So it's like, if I couldn't do it, I don't think that's realistic.
Yeah, but I do understand, why people say, is there another option? Well, when somebody's got a knife lunging at somebody, what's perceived to be a knife, options are very limited in that moment, right? And that was a 5-second clip you just saw, right? That's a 5-second clip, and he got 4 shots off and stopped, and the woman didn't get stabbed. What would the alternative be? And I think a lot of people don't really think about that. Do you want that cop to make that decision in that particular time? And again, I think it also goes to the counterpoint that this is why I think if that cop did make a mistake, let's say that wasn't a knife, that was something else, and the cop did make the mistake, then do we prosecute that cop based on the information that we have? And I think that's where it starts getting a little more interesting. Right, because let's say that wasn't a knife. Let's say that was a paper mache or something. Something that we know that wasn't serious, but just looked like a knife. Would a reasonable officer facing those same set of circumstances, would they have acted in that way? So I think that's another interesting piece. And then a lot of people then I'm hoping start understanding the law and start understanding that, police aren't perfect. And the law does have some flexibility where if a reasonable officer would make that same sort of circumstance, then you have the same issue. Then you have a clean shoot. So sarcasm, shoot to wound. If the cop isn't responsible for where the rounds lands, sarcasm because it never happens. Yeah, you're responsible for where those rounds go. So let's just get into it because we've teased up the George Floyd so much. We've teased it up. All right, let me pull up the charges which he did get convicted of. Here we go. I'm sorry I'm a little slower today because I had all this keyed up, but then I had to do a hard reset on my computer. All right, so here we go. So first, what do you guys think about the verdict? Do you think it was fair? Do you think it was just? Do you think it was wrong? I'll start with you, Legal Bites.
I think that there was evidence to support the conviction on all of them. I think as soon as I learned about Minnesota's crazy felony murder rule, and that is unlike pretty much any other state, I think, in the union. I figured that felony murder was going to be a given, and as soon as that happens, it's kind of weird if he's convicted of second degree murder but not third degree murder. I feel like psychologically for the jury to do that, it would be a weird place for them to have to go through, because it's like, second degree murder, it's more it's heavier than third degree murder. But and same thing with manslaughter. So I don't know. I figured that just kind of the psychology even of the jury going through that process, they probably were going to convict on all three.
Well, what about the time frame? Because it took them what, like
10 hours?
To come through it. Did you expect it to be so short, or did you think it was going to take a little longer?
I don't know. Because juries are so notoriously unpredictable that, there could always be that one person that just wants to go through everything and is just unconvinced and, just holds everybody up. So, I mean, there's always a possibility of having a hung jury, but I didn't see them acquitting him, because that would also require a unanimous jury for that. So, yeah, the timing of the verdict, I wasn't necessarily expecting, but I also wasn't terribly surprised when it was after 10 hours of deliberation or something like that.
Yeah. Well, what about you, Uncivil?
I think that, first of all, I don't think 10 hours is as short as some of the other commentators have been saying from my point of view. One of the reasons is because, at least in this case, I don't know if it's true in all Minnesota cases, but the jury is allowed to take notes, which is not by any stretch of the imagination the norm across the nation.
Right.
So they're allowed to take handwritten notes, and it's, just pretty well-known basic psychology, or that when you write something down, it makes it easier to remember without even referencing it back. The very act of writing it down more commits it to your memory. And then, of course, you have it there to reference to. So they all had their individual notepads, which they were allowed to bring back. And they had all obviously been there the whole time listening to everything. So the question, the issue would be what questions were they discussing amongst the others? So did they need to go through every piece of evidence again? No, I mean, they already heard it for the first time. So they'd only need to hear some stuff if they had questions on everything. So I don't think 10 hours strikes me as capricious. It doesn't strike me as unduly short, as some commentators have been arguing. With the third degree murder statute, I obviously have a legal issue and I have a bit of a factual issue. So the legal issue I discussed on my channel earlier today. On the factual issue, because if I'm a juror, I'm not allowed to consider that legal issue because I've been instructed on the law. So I'm not allowed to factor that into the consideration. So we'll just go with the factual element. So the factual element that I had a little bit of trouble with on third degree was this idea of an act that's eminently dangerous. And I had a little bit of problem getting there, because some version of what Chauvin did was authorized procedure at the time. So presumably, if he had followed the procedure, that couldn't be eminently dangerous because it was authorized procedure. So the question, I suppose, would be, did it so deviate from the policy in such a manifest way? This is how I ask the question, that it somehow became eminently dangerous, even though a different version of it isn't. So like culpable negligence obviously isn't a problem, because like he deviated from the policy in a negligent way. I'm there on the manslaughter, no problem. The intent to commit assault because of the way second degree murders were in, no problem. I'm there. But third degree murder because of this particular aspect, I'm not so sure about the act in eminently dangerous aspects.
Well, it's interesting because a lot of the it's weird watching a lot of the commentators on the right discuss this case, because one of the big issues they have put forward is especially against the second degree felony murder charge is intent. And they say Chauvin didn't intend to assault Floyd. And like Ben Shapiro's been saying that, Robert Barnes has been saying that, like all these big has been saying that. But even in the jury instructions, it specifically said he didn't have to intend to assault him. He just had to intend the act, you know, the slap, the chokehold or whatever. So
it's harm is what you meant to say.
Well, no, you don't have to intend the harm. You just have to intend the act. Because it's a general intent crime.
Yeah.
So, and it seems like that reasoning, which is still pervasive, because that's what Ben Shapiro said today. He was like, the verdict is wrong because they didn't prove that he intended to commit an assault. That's just legally wrong. So it's I think it confuses people, because even if you don't agree with the verdict, I think a lot of people don't agree with the verdict because they are under the impression of they are under the wrong interpretation of the law. They believe that this fake intent is the intent that's necessary. And I will say this: if the state had to prove that Chauvin intended to assault Floyd, you don't have that. That's not guilty. But that's not what they had to prove. And I think that's the disconnect with a lot of people who are out there who believe Chauvin is innocent because they're saying, well, they didn't prove this intent. And another big issue that been brought up is the causation factor. A lot of the right-wing media, Ben Shapiro, Robert Barnes, the rest of them, continue to bring this causation element to it and say, well, they didn't prove that Chauvin was the sole cause of the death. And that's another thing that's legally incorrect. He doesn't have to be the sole cause. He has to just be a contributing cause, right? And they say substantial contributing cause. In other words, it's the but-for test, right? But for Chauvin's knee to the neck, would he have still been alive? And I think if you have 4 doctors for the prosecution that says, no, he would have died, right? And that's what killed him. And the doctor for the defense is saying, well, I'm really not sure. To me, that's a win for the prosecution, right? Because it's not like the defense's Emmy is saying no. So I think those two things have people just so confused because they're like, you know, and that's what they're hanging their hat on. But I think it's just a misinterpretation of the law. So when it comes down to this verdict, based on Minnesota law, I think it's just too hard to say that the second degree murder doesn't hold. I don't think it's just. It's exactly what that statute is for. You committed assault, you know, and I think the manslaughter, obviously, I think that's good. But I do have issues with the third degree murder because I don't think this was a depraved mind. I don't think it was at that level. Do I think this was an assault? Yes, but I don't think this was third degree murder. And that's just based on the facts that I see. I don't think it's almost with third degree murder, the depraved that standard. What's a good example for that, Kurt? The depraved mind one.
Well, the analogy I came with is this difference between shooting into a crowd, whether I'm targeting someone or not.
Yeah.
If I'm not targeting anyone in particular, so if I shoot into a crowd and I'm targeting someone in particular, that's second degree. If I'm not targeting anyone in particular, that's third degree. The way the Minnesota statute's written. So that's the way it's written. So.
I mean, I can see though how the jury came to that conclusion because. I mean, so depraved mind, it's a conscious disregard for humanity, right? Basically. So that was the definition. Yeah. And I can see how, with the evidence being what it was, how the jury came to that conclusion though, because they had the testimony of all the bystanders, you know, the fellow officers, everyone that was kind of like, well, should we turn him on his side? You know, and then, you know, that was the officers, and then the other bystanders, you know, shouting at them to get off of him because he had passed out. You know, like they can, you know, I think that the jury probably looked at that whole situation and decided that on its own was a conscious disregard for a human life or whatever. So I don't know. I can still see how they got there, even if you think factually that it's not quite strong enough. I can see it.
Yeah.
I always thought depraved mind is the I don't care. That's
Yes.
sort of how I always thought depraved mind. So an intent is I want this result. Depraved mind is I don't care about what I'm doing.
Right.
Or
Just
the
so
harm
reckless.
that's causing. I don't care. I don't have any empathy. It's a lack of empathy.
Right. And so I think because of the fact that there was so much time that he had his knee on the neck, and you know that they probably looked at that more like, I mean, he had 10 minutes to take his knee off of his neck. He had already passed out long before he actually did, eventually get off of him. So that, that's a long time for him to be able to deliberate and think about, like, well, maybe I should get off of him, maybe I shouldn't. So maybe, I can see how they may have looked at that as having a total lack of empathy, a total kind of like a cold heart essentially towards George Floyd, who was already on the ground, no longer resisting.
Yeah, I had no problem with it.
Yeah.
I had only problems with that other element. And so the depraved mind, I didn't have a problem with. The academically dangerous, I don't know if you have any thoughts on that specific issue, legal bites or not, but I'd be interested to hear your analysis.
So I know that initially they didn't have the 3rd degree murder charge because Judge Cahill analyzed the statute as saying that there's a difference between, imminently dangerous to others versus dangerous to another. And so he said that because it's not multiple people that were put at risk, that therefore 3rd degree murder was inappropriate. But because there was another case that had gone up on appeal and the appellate court, said, no, this is appropriate for putting just one other person in danger. That was why he added it back again. But I do understand that it's now going to the state Supreme Court. But yeah, I don't know. I mean, if you go by a very strict interpretation, just statutory interpretation, it should be the kind of situation that is, dangerous to others, to multiple people, the kind of thing that dealing with explosives, for example, that's something that's, imminently dangerous to others, to other people, multiple people around you, as opposed to just putting one person into a stranglehold. But I don't know. I mean, I don't know.
The thing that I did like about the reasoning of the appellate court was the singular, the plural includes the singular. Mm-hmm. So in other words, if I'm shooting into a crowd, that's imminently dangerous. But if I'm actually just shooting toward one person, it doesn't matter because I don't need more people because of the singular is included within the plural. So
and
that's kind of how
Low. That was also in that Low decision from 1896 said the exact same thing. Now, I think 1896. I think the way that the Supreme Court phrased it in 1896 wasn't quite a holding. I think it was more an illusion. So the case that you're referring to, legal bites, that was earlier this year, is a case called Knorr. So I think Knorr was solidifying the suggestion that was in Low with respect to how many people need to be threatened, and a person is sufficient to be threatened, but still. Nor does not speak at all on its own terms to how many people are targeted. It just doesn't deal with that issue at all.
Yeah, it doesn't deal with that.
And when the Chauvin appeal came back, because there was an appeal already on this issue about Knorr, because the judge initially denied reinstating the 3rd degree murder because he said Knorr was not binding precedent at that point. That was his view, because it could still be appealed or whatever. So he said it's not binding precedent, so I'm not going to give 3rd degree murder because I don't think Knorr is binding precedent yet. So it went on appeal, and the appellate court said, yes, it is. It's a binding precedent. The moment was decided whether or not it's, appealed or not. So we said, okay, Knorr is binding precedent, but that still doesn't speak to the other half of the answer. The judge at least never orally spoke to it. So I don't know if there's anything in writing about it from the judge. I'd love to read it, because if they have a way to get around Low, I'd love to see what it is, because it doesn't make any sense to me.
Yeah, well,
we'll find out if I'm right eventually, I guess.
My question to you, Pete, to you guys was, what about the other 3 cops? Because now you got 3 other cops that are looking down the barrel of a gun, right?
Right.
They're looking down the barrel of a conviction. Because if I'm their defense attorney, I'm like, we got to have a hard conversation, because you see the arguments Nelson made. I think Nelson did a fantastic job. Agreed. He made all the arguments I would have made.
Right.
And his client is looking at a full conviction, right? He's hoping not to go. He's hoping to have a possibility of getting out one day. That's not going to work. What can we do as these other officers? Go ahead, Legal Bites.
Yeah, I mean, so now they're looking at aiding and abetting, and there's already a conviction for what it is that they are charged to have aided and abetted. So I think that they're gonna have, like you said, they're gonna have some hard conversations with their counsel as to what to do, whether to take a plea deal or just how to fight it. I don't know. I mean, it's granted, you have these also are different situations because you also have two officers that were brand new. One of them, it was like his third day of work or something, wasn't it?
Something
And so that's very different from Chauvin, who had 18 years of service.
Years.
Yeah. So that's very different on its own. And then you have the fact that, another one of them was, I mean, all he's being charged for is basically being, the lookout, essentially keeping the crowd back. That's what he was doing. And he's supposedly, aided and abetted this whole thing, which I don't know. I don't know that I would agree necessarily that that's a very strong case for him. But even still, this is,
well, just to clear it up, two of the officers, that was their third shift. Two of the officers were new officers.
yes.
And the other two were training officers. So you had the two older officers were training officers, and you had two new officers they were training.
Right.
So that was the situation. So in other words, for the two new officers, that's
training day reference and before training day reference.
Hold on. Before I get to Kurt, let me get some of these super chats out, because I know Kurt has a really enthralled view on this, which I actually agree with. So just found your channel a few days ago. I really appreciate the perspectives. Thank you so much, Kevin. Thank you so much. I really appreciate the super chat. Anime. I got 5 transformations and 3 special abilities. Cops. This is for the other case. Cops say best I can do is 1 Fist of the North Star punch. Fist of the North Star. I did love it. And everyone else and nanny. All right, we are going to a Fist of the North Star reference. Somebody's showing their age right there. Isaac says, question for Kurt. What do you think was Cahill's biggest strength during the trial?
I thought it was very even, all things considered. I thought he was fair. Obviously there's some decisions I would have come out differently. I would have come out differently on the third degree issue. But I
what
didn't
happened?
have...
He came out the same way you came out. Remember, he got appealed. He said no third degree. It doesn't apply.
Well, he ultimately reapplied it.
But he was forced. That's because he was forced to.
No, he wasn't, because it wasn't, because even the decision on appeal, when it said nor is binding authority, even that decision, the Chauvin appeal, said we're only speaking to this issue. We're not speaking to the other issue. So even the Chauvin appeal didn't bind him in this respect. It said nor was binding authority, but nor doesn't speak to this issue. So I can still say nor is binding authority and be like, okay, nor is binding authority, and so what? I'm still going to better authority. State Supreme Court beats Court of Appeals.
Of course. So, yeah. That's true. Yes. I think we might be working on this, just trying to understand how this case differs from Tony Tapia. Well, I've even seen that video. Derek Schaefer or Kelly Thomas, state law. Well, yeah, state law is definitely a huge issue because this is Minnesota. The Tony, I think, Tempa case, I saw that. That's a totally different case. They weren't on the guy for the full time. There's a whole different fact pattern. Even though this was an in police custody handcuff death in the same manner with pretty much the same technique, but I think the facts and circumstances are different. The cops were asking him if he's okay. They were talking to him the whole time. He was kicking, and it was a different case than George Floyd. But maybe we can go over it one time. But yeah, if you're asking me what I think about, I'm not sure if you guys know about the Tony Tempa case, but it's similar, but there's a lot. It's not the same at all. 300 of you haven't liked this. Disappointing. All right, thank you, Navy. So Kurt, let's get back to it. All right, the accomplices essentially. Those are the 3. So you got the 2 new, the one vet. They're all looking down the barrel of a gun because, like I said before, they're going in probably making those same arguments, right? The training. I was trained to do this. I was doing this. So what do you think about the next 3 officers? Do you think they get convictions? Do you think they plead out? What's up?
Well, I mean, what a jury will do, who will say? But as to me, I don't think they should get a conviction. And the reason is because of the mental state requirement. Because every person in this equation has a different mental state. and what is going through their own head, because they're different people, because of course they do. So what is true in Chauvin's head isn't necessarily true in anyone else's head. So you have to take the effort to put yourself in the different perspectives. So the jury went into Chauvin's head. That's what they just did, and said, okay, we find intent for him. We find his mental state. Okay, fine, great. So now when we go to the other officers, we're asking a different question. We're not asking the question for the other officers, did they intend to commit an assault? That's not the question anymore. The question is, did they intend to aid a crime in progress? And one of the critical elements of that is that they have to know it's a crime in progress, right? So one of the examples I come to, which is maybe slightly silly, but it's what I come up with, suppose a group of bank robbers come out of a bank, all calmly, and there's no audible alarm, and they hail a cab, and they get in the cab and they drive away. Is the cabbie guilty of anything? No. Under the hypothetical I just gave you, the cabbie has no reason to believe they're bank robbers. They're just strolling out of the bank calmly, with their satchels or whatever, and he's taken him to the airport or whatever, just another day for him. So he doesn't know there's a crime in progress. So he can't be guilty of aiding and abetting under the scenario I gave you. If there's an alarm and like shooting, that's obviously different, right? Because it goes to knowledge. Okay. So let's think about how that applies here. So as to the other three officers, do they know that there is a crime in progress? And to me, I think the answer is no. As Legal Bites points out, some of these guys are so new on the job that it is difficult to imagine that they can come to the knowledge of a crime in progress. They might think that there's something wrong. They might think that there's a deviation policy, and they did, and they were warning Chauvin about it. So they were well aware that this was outside of the norm. But then again, if you're like 4 days on the job, are you really going to be like, shoving the guy with 20 years experience off the other guy? Are you really going to have the courage to be like, well, I'm the rookie, I surely know better? This would be the rough equivalent of a brand new ensign, shoving the captain, off the deck of a ship. I'm not sure this is necessarily going to fly. So it's a lot to expect here from this person who's green. So I'm trying to say, okay, what did they know? What didn't they know? We have the guy who's the lookout, which I think is the most insane thing I've ever heard of in terms of framing. But does he know? No. His attention is obviously mainly on the crowd. His knowledge of what's going on with Chauvin is peripheral for the majority of the time at best. But we got the brand new guy. Hold on.
But okay, the lookout is brand new. He checked his pulse. And he checked his pulse.
Yeah.
So now
his knowledge is intermittent.
So I think even if he's new, when he checked his pulse, now you're starting to have something. Now I think you're starting to have a different conversation, right? Because that's what the people are going to say. The state's going to say, well, when he checked his pulse and he saw he didn't have a pulse, then what would a reasonable officer do who's been trained, right? What would they do?
My knowledge at that point would be he's dead. But that's not the knowledge I need. My knowledge isn't he's dead. My knowledge is a crime is in progress. That's different. So that's where it's breaking down for me. So yeah, sure, he checked his pulse. That gave him knowledge that Floyd was dead. Does that give him knowledge that Chauvin was committing a crime? Not inherently. I mean, not obviously it doesn't. So you have the brand new officer who's like 4 days on the job.
That was that guy.
You have the other guy who's like in a different position, and they're all warning him actively at the time. They're all like you should probably do something about this. You should move him off. This is a problem. So they were taking steps to remediate. So your step here is basically a failure to act. So you're using a failure to act, which inherently is a bit problematic for a conviction inherently, because just to convict someone for not doing something. So I guess the prosecutor's theory is they should have shoved him off the guy and shove Chauvin off of Floyd. And because that didn't happen, that they formed an intent to not intervene or something. Well, it's too much for me.
Well, there's a little more nuance to the charges, and what I mean by that is
carry on.
The lookout is different, right? The lookout, I actually agree with you with the lookout. The other two that were holding him down, they're going on more of a theory of an accomplice to the assault, right? Where you don't have to wear, if someone else, Chauvin was on his neck and his upper back, but you had somebody on his mid back and holding him down with his arms up. They're going with that theory that also was an assault. that, though Chauvin was an assault, this was an assault. Now, I'm not sure if they're going to charge the second guy with felony murder, but theoretically, if we're talking about Minnesota felony murder, the guy who was on Floyd's back with Chauvin, you may also be able to get him for felony murder, right? The guy, the commission of an assault, that he was, if they're saying Chauvin committed the assault, he's just as culpable for the assault. And you had somebody die in the commission of the assault. You got felony murder for the second guy.
See,
the third new guy is like you're saying. I agree. He should.
This is for me why, like, the factual analysis and why the facts matter so much. And you have to look at this at the right resolution of detail. Now, you might be right in the end. You might be right, but I can splice that difference, at least in my own mind, and I can do it fairly comfortably, where I can say that even though the other officer was touching Floyd and putting pressure on him, his justification hadn't lapsed, even though Chauvin's had. I can split that difference, and because it's the nature of exactly what they were doing, right? Exactly the nature of the act. So the precise aspect of what they're doing at the time, their mental state requirement is not exactly the same. So, for me, if you're going to try not accessory, because I thought these were all being accessory charges, was my understanding. If you're not going to go accessory and now try to charge them as a principal actor, so you're in the same position as Chauvin, boy, that's a tougher.
Not all three of them. I'm talking about the other one that was.
Yeah, I understood.
Top
but
of the back. Yeah,
even that's tougher for me to say because it's a different position. But it's like, okay, did he intend to commit a felony assault? Jeez, it's a different posture. Literally,
yeah, because only thing he has to do is continue to act. Is handcuffing somebody and holding them down past that time. Do you have a felony assault? It's.
Am I slicing this Am I slicing this the wrong way, legal?
Alito, what do you think?
So, so in order to get to felony murder, there has to be third degree assault is what they had in Chauvin's case. Mm-hmm. So there has to be an unlawful touching. That's an unwanted touching without someone's consent that leads to bodily harm. And in that particular case, it has to lead to serious bodily harm. So, even if he's just touching George Floyd, his own personal touching would need to be the kind of touching that would lead to serious bodily harm. If he's on, so let's take the guy that's next to Chauvin, the guy on his back. Yeah. Potentially there could be space for him to have caused bodily harm, because they were talking about in this case that because there was a body on top of him, George Floyd was between a human body and a very hard ground, right? So his rib cage couldn't open up, et cetera, et cetera. So you have that second officer that was the person on top of him. Potentially there could be felony murder in that kind of a case, potentially, but of course, it would come down to a battle of experts again, because you have not only him, but you have Derek Chauvin. So again, neither one of them have to be the only cause. They only have to be a cause, right?
Or substantial cause, yeah.
Mm-hmm. Right, exactly. And so I think that in his particular case, maybe you could have that, but. But in order for it to be an assault, again, it has to be an unreasonable force, because otherwise he has the ability to use force as a police officer. Yeah. So it comes again back to the, his reasonableness in using the force that he did as a brand new, because he was one of the brand new officers, right? That second officer.
I believe the second officer was the older one, and the oldest one was on the feet.
Oh, okay.
But I'm not sure. It could be reversed though. But that was my understanding. But even though
I was under the impression that the second officer is one of the new guys.
Let's go with that, because that may be right. Mm-hmm.
Yeah. So and I do remember also that he was there was body cam footage where he asked Derek Chauvin, should we put him on his side, take him out of the prone position?
Yeah.
Should we put him on his side? And Chauvin was like, no, we're fine like this. So he's, as a reasonable officer, not just a reasonable officer, but a reasonable brand new officer who has been trained kind of, but is still being trained. Yeah. He's going to be, I think that a reasonable officer in his position would be looking to his training officer for instruction in that case. So I don't, I mean, that's really kind of what it would come down to for him.
No,
So-
I agree. I think if you're asking me just off principle, I think the 3 officers who were there, they weren't there to assist in an assault. Obviously, they were there to assist, and the 2 officers who are obviously new, I don't see any real criminal liability for them. I understand why they're going to charge them and they're going to fire them, but I just don't see any criminal liability because you're really talking about, like Kirk said, you're talking about 2 brand new guys and the ship captain, and then the ship captain telling you this is the way we do it. You know what I'm saying? What would a reasonable new officer like you said, Alita? What would a reasonable new officer who's been on the job for less than a week? What would they do? And that's that's the standard here. It's not what their intent was, but what a reasonable officer in their position was. So it seems like you guys don't think that the new officers would lose, but there's the legal, the philosophical argument, but then there's the legal reality. The legal reality is Chauvin, no matter how great the Chauvin arguments was, they went down in a heap of flames. Yeah. Now these officers are, more or less Chauvin's boys, and they're going to trial in the same jurisdiction with the same arguments that they know has failed. As an attorney, though, that's a hell of a bet because you're talking about life imprisonment or multiple decades imprisonment versus something maybe lighter. Do you even consider a deal if that's your client?
I'm not sure the prosecution considers a deal, to be quite honest, because the political pressure on
they got them charged. They got them charged. They charged them. Of course, they're going to consider a deal. They charged them.
Why? No, I don't think they might. I don't think they would. I think they're going to press it all the way just for they won't settle out. Even if the defense want to, they're going to go to the end of the page, man.
Yeah, I think you're right about that because of the overall climate.
You don't think they'll deal?
I mean, if you think about it, I mean, what's the PR that comes out of that the prosecution makes a deal with cops, dirty cops don't have their trial or whatever, the messaging that gets put out to the public is, we want accountability for these officers. We want to have a trial. And instead the prosecution decided to just make a deal with them.
I hear you. No, I think you're right, but I think the reality of a trial is that, especially as you guys are saying, like we all agree that we all agreed with the Chauvin conviction, but we all are torn between this other conviction, and most people are torn with the other officers when you actually hear the facts. So I don't think a conviction is as with Chauvin. I understand you can go to the drill with it because it's obvious you got him on cameras. There's a murder on camera. What can you say? But I think these other officers, I think there's a lot of gray area here. And I think if sometimes justice isn't a conviction. It isn't a jury conviction. It is a deal. And I think especially for the guy who's on the job for 4 days, I don't see how you get a conviction at trial for that guy.
Man,
I don't see how you do it.
The Chauvin jury was hard, man. Being on this jury is going to be brutal, man. Because you got 3 different officers facing 3 different charges. So that's 9 different things you have to consider. You might as well break out a little matrix with your 9x9 grid, tic-tac-toe style or something, man. But yeah, I mean, that's going to be a tough jury to be on because if the jury's doing their job, it could be a fight. It could be a real fight.
I do want to talk to you about the aggravating factors. We'll talk about that in a second. That they're going to actually do a factual finding of soon to see if Chauvin can get more time. This Salty said in Noor, didn't he shoot over the top over the other cop at the victim? Does other include the target?
I don't remember that well. The facts of Noor.
I gotta look at Noor. Holding. Here is uncivil law, interfering with a corpse.
No.
So let's talk about Blakely. Now, the next piece, the next piece of the Chauvin trial is Blakely. Now, what Blakely is that if you're convicted, now it's weird in a sense, but most states have sentencing guidelines. And so, like, for instance, in this case, Chauvin got convicted of 2nd-degree murder. And the sentencing guideline says if you're a first-time offender, sentencing guidelines says you get between 10.5 to 15 years in prison, right? That's even though you can get up to 40 years, the sentencing guidelines only gives you between 10 and 15 years. So the judge has that wiggle room. It can go less, but can't go more than 15 years.
I think he can go up to 40. He has some discretion.
Yeah, I think you're correct because the guidelines shouldn't bind him that hard.
But his baseline is like 10 to 15 years.
No, but this is the Noor issue. I thought that too. But this is the Nora issue. This is the Blakely issue. So the Supreme Court said that in this particular context, because if the judge is going to enhance the penalty over the sentencing guidelines, there's a formulation of aggravating factors. For instance, were there children involved? How long was it? Was this person, doing this crime under color of state title, or some right or something like that? And since those are questions of fact, by law, by due process, for instance, by law, but for due process constitutionally, those issues of fact have to be determined beyond a reasonable doubt by a jury. Were there children there? Did you have a weapon? Did you have this? Now, most states have these aggravating factors already in the statute, but Minnesota doesn't. They have them within these sentencing guidelines. So Blakely says, well, if you are going to enhance it over the sentencing guidelines, and it's based on those facts, those findings of fact that there was a gun, there were children, then you have to prove that to a jury of their peers by a reasonable doubt before you can have that enhancement. So that's why they're doing the Blakely hearing. So that's why generally, if the jury comes back guilty and then they go to say, well, or were these any aggravating factors, generally that jury will say, yes, there's all these aggravating factors, right? But so that's why Chauvin said, I don't want the jury to do the aggravating factors. I'd rather the judge do that and be the finder of fact. And that was the waiver of the jury. So that's how the Blakely interacts with Chauvin. If Chauvin now, the court has to find that these aggravating, I think some of the aggravating factors were there children involved. Was he acting under color of state title? The number of defendants, right? If it was like a beatdown, 5 people versus 1 person, all those factors would aggravate it, allowing the judge to give more time if he finds them beyond a reasonable doubt. Right. Oof, I know that was a lot. So that's
you got it all, but you got it all. But I don't think there's anything in any of that precludes the judge from maxing out if you find sufficient aggravating factors. That was legal when I understood.
Yes, but the only way you can find those aggravating factors is beyond a reasonable doubt by a finder of fact, which is generally a jury. That's why he had to with the jury trial. So the jury would go and say, okay, there were children there. That's an aggravating factor. We find that aggravating factor beyond a reasonable doubt. Then the judge can impose a higher sentence outside of the sentencing guidelines.
Yeah,
it's like a separate little trial.
I think there's going to be a pretty substantial upward enhancement. I don't think they necessarily will max them out, but I think the guidelines recommend 150 months. So I would recommend times 2 would seem like plausible. So like 300 months, which is what about 24 years, something like that. If I'm at the
25,
something 25. Like that. Yeah. Is exactly okay.
I think, because 150 is 12 and a half.
Oh, there you go. So so I was only off slightly.
but prison years are different than regular. Like I think prison years are only 10 months versus it's weird. 10 months is a prison year versus 12 months. So for every
are you thinking about the fact that the sentence can be reduced after the fact because of good behavior? Are you thinking about that aspect?
No.
Are you thinking about good time credit was the words I was looking for?
I'm possibly thinking, because I remember when we were doing it, when we used to do it, a year was actually 10 months, not 12 months. And I forget the reason why it was only 10 months.
Really?
So you would think about it in 10-month increments. Yeah. I trust me, it's been so long. I might be messing that up. But
you're telling me in New York, we're well back on the really old calendar before Julius and Augustus got their calendar. That's how old school we are. We're still the 10-month calendar.
There was some reason for it, but I forgot what the reason was. But there was some reason for it where prison years were different than regular years. I'm not sure if they take vacations off vacation. I don't know why it was, but it isn't a 12-month year. But whatever. If somebody's getting 300 months, they're getting 25 years anyway. So you think there's going to be a 25-year sentence in this?
Yeah, I think that's quite plausible, especially because the judge is going to be thinking about the good time credit that Chauvin gets. I forget what it is in Minnesota. Any number I make up will be wrong, so I'm just going to not try. But I think because of the color of law aspect is going to just and the length of time and the number of warnings that he was getting and the amount of information that he was getting and that smug ass look on his face. Yeah, I think that's worth it times 2 from the judge's view. Let me put you this way. If it was judge on civil law, it would not be ending particularly well for Mr. Chauvin at this point.
So what do you think? You also think he's going to get a quarter too, Alina?
I don't know. I don't know. I'm not sure. I mean, I don't
Are you a
know.
softie?
A little bit.
Okay.
I mean, but and not necessarily that I'm saying that he should only be, spending 12 and a half years, in prison for this, because obviously a man died,
Yeah.
but I don't know. I mean, it really comes down to trying to get a read on Judge Cahill and what he's gonna, like, how we think that he is going to come down on it. I don't know. But
I don't know. It's who knows? It really depends on those aggravating factors. Because
Right.
if he finds those aggravating factors, then I think it's over. I think you're looking at maybe a quarter. But if it's not, I think you're looking at maybe 15. Because the mob wants 15, right? The mob wants the upper echelons. But we'll see. We'll see how this judge works. What about this? Somebody's talking about thoughts on how UK handles people with knives. UK they don't. The police don't. I'm assuming the police don't have guns. So if somebody has a knife, they must end up in a knife fight or something. I don't know.
Yeah, I unfortunately don't know enough about UK law to really be able to comfortably comment on it.
I know here though, if you want to get shot, pull a knife out and charge at a cop. They're not gonna. They're gonna shoot you. It's just here we have guns. It's just the way it works.
That is very true.
So I don't know. It seems like people. Everybody keeps thinking that a knife isn't that dangerous. When you're in close quarters, people, knives are more dangerous than guns, right? Guns are ranged weapons. Weapons, so it gives you distance. But when that distance is gone, the knife is. If you're in close combat, that's why they give soldiers knives too. When you're in close combat, a knife is actually a better weapon to have than a gun.
Right. I've spent enough time cooking dinner to know just how dangerous those knives can be.
Shooting a steak, right? Tenderize it.
We won't ask deeper thoughts about your psychology, about what specific thoughts are going through your mind, but okay.
So here's a good question. Was the drug dealer used as a pawn, no immunity? I believe so. I believe the drug dealer, alleged drug dealer, number one. I believe this guy, who obviously he took the fifth. I think the state knew that was a bad witness for them. But the state doesn't have to give you immunity to testify, right? So the state knew this is a bad witness because he's in there with the drugs, giving fake names, doing all this stuff. Has multiple warrants for this stuff. And, everybody knows that was Floyd's drug deal. They had his phone. They looked through his text messages. So it wasn't like this was a secret. So does the state want him to testify? Obviously not. That's why he was called by the defense. The defense said we want that guy to testify. But he needed immunity. The state didn't give it to him. That's the way the game is played. Go ahead.
I don't really know what much of value he could have really offered that would have really helped the defense if you think about it, because the questions would be like, what the toxicology was at the time, which you got from the medical examiner. So if the drug dealer says, yeah, he was taking drugs in the car, or I was giving him drugs in the car, or whatever, I'm not sure how that information really adds to the equation. Because we already know that drugs are in his body. So, I mean, I'm not sure what value it really has here for the defense.
Yeah, no, I definitely agree. I mean, that's why I was really confused about the whole, was it a pill in his mouth? Was it gum in his mouth? Because it really didn't, that whole exchange didn't really matter because of the toxicology report.
Yeah, I think they were trying to say that the defense's theory was that he had just taken a pill. It takes 5 minutes to work, and then when he died, it was because he had just taken a pill. He overdosed in 5 minutes. So their theory of the crime was Floyd overdosed, right?
Right.
This was an overdose. This was a heart attack. Everything but Chauvin's name. But the jury didn't.
Well, it'd been real nice if someone medically testified to that theory. That would have backed them up. That would have been great. Apparently, couldn't find anybody who would be willing to say that. So I really think it was the drugs were the dominant factor here.
They found a guy that said it was inconclusive. he didn't know,
which isn't that helpful. Any more than that.
Not when you have three other experts on the other side saying it is conclusive and it was his knee.
Yeah. So what do you guys think about Nelson? Do you guys think Nelson did a good job with this, or do you guys think he had issues? Go ahead,
I
Aaliyah.
think he did a good job. I saw some of his voir dire that wasn't necessarily I think that effective, because I think voir dire can be hard, because when you're picking a jury, you only have so much time with with the various members of the jury or potential jury, and you're just trying to figure out, like, who's going to be a reasonable person, who's actually going to listen to the facts. But I mean, I think in his case, it's like it's hard to not just like kind of lecture to people, be like, you're supposed to be, you're supposed to allow yourself to change your mind, right? You're supposed to listen to all of the evidence, right? You're supposed to use your logical brain, right? But I think there's there are some ways to go about it to try to figure out somebody's more controversial thoughts, rather than just trying to get people to respond like, yes, of course, I'm socially responsible. I know exactly what everybody wants me to say in this situation, and I'm going to say that so I can be on this jury. But I think, aside from that, I think aside from some of his questions in voir dire being a little bit ineffective, I think overall, from what I saw, his opening, his closing, a lot of his cross, a lot of his direct examinations, I thought he did a good job overall. I was impressed.
I agree he was overall competent. Certainly his flaws, some of that's Monday morning quarterbacking, which might not be particularly fair. I will Monday morning quarterbacking the shitting out of his clothes, though, because that was just painful. So
you think so?
Yeah, for 3 hours of I lost consciousness, I think, in the middle of it, and I forgot everything that happened. I mean, what did we talk about?
That is true, because I watched his clothes and I thought at first watching it, I was like, okay, this is okay. But at the end of it, I was happy it's over. And that's me being able to go to the bathroom and do whatever I want to do, and stop it and start it. I just imagine a jury. And don't forget, they had to break his closing so they can go to lunch too. So a lot of that was probably just
look.
Gone, like, right out.
To break this into computer science terms, I had a memory overflow. Okay, you kept adding. I ran out of register space, and I wound up in the negative. Okay, I was worse off at the end than I was when I started. That's what I was. So yeah, that closing was brutal. I thought his cross examination was very good. So I thought it was really good on cross. The witnesses that he had for defense, I don't think were particularly great. I don't know if it's an issue with prep or the witnesses he's able to find, but there's left something to be desired there. But overall, I thought he did the best he could in a horrible, horrible world. I'm sure he knew it wasn't going well from day one, but he did yeoman's work. So, maybe the other 3 officers will be better off. I mean, their odds are much better.
Oh yeah, I think the odds are better. What about this? Is it how was there no reasonable doubt? All right, so let's just go over some of the more reasonable doubt from the right. I like to call it reasonable doubt from the right. First, did Floyd die of a drug overdose, right? People are saying that was one of the things. He had 3 times or 4 times the legal limit of fentanyl. But we saw that there are people driving with 50 times the legal limit. And we saw that he had a high tolerance to it, right? Because at one time, then they testified he took like 8 pills at one time and was all right. And they were like, so he had a high tolerance to it. And let's not forget, you had 4 or 5 doctors say that he didn't die of a fentanyl overdose, nor did the defense's expert witness say he died of a fentanyl overdose. So I think if you're talking about reasonable doubt for a fentanyl overdose, you just don't have any evidence to support that, right? Nothing that was submitted at trial. Do you guys agree with that or no?
Agreed.
Yeah, the key factor here that everyone keeps forgetting, including Ben Shapiro for that matter, which drove me crazy, is that you only need to find that Floyd is a substantial cause. Not the major cause, not the dominant cause, not the principal cause, not the sole cause. So as I keep trying to remind everyone, you can believe the drugs killed Floyd and believe that Chauvin killed Floyd. And then if you believe both those things are there, you just need to find that Chauvin is a substantial cause. So, for me, the fact that, there was fentanyl in his body, there were other things going on. He had a enlarged heart. He had a constrained aorta. It was tightened up from various conditions. So we had some negative health conditions going into this exercise. And what is the immediate legal answer that comes to everyone's head? That's right. Eggshell skull. That's right. That was the right answer to that question. We know the answer to that immediately.
Yeah.
So yeah, he was in a weakened position, but that sucks to be you if you're Chauvin. You did some bad things, and because of the weakened condition that Floyd himself put himself in, sucks to be you. So yeah, beyond a reasonable doubt, I see pretty easily here.
Yeah. So the fentanyl, we had the causation issue, right? As Uncivil just explained it. And the second thing was the intent for assault, because everybody's like, they didn't prove that Chauvin intended to assault Floyd, but obviously they don't have to prove that. That's just a misstatement of the law. Go ahead, Alita.
Yeah, I mean, it's like you said earlier, it's a general intent crime. You don't have to actually intend the result. You just have to intend like doing the things with your body, right? Like it's basically like for a general intent crime like assault, the way that you wouldn't have intent is that, let's say you have like a neurological disorder and your arms just flail out, without any sort of conscious thought by you. That is a situation where you don't have general intent. Or likewise, if you are, let's say, you have a propensity for sleepwalking and you were completely unconscious when you assaulted someone. That's also where you don't have any kind of intent because you're not conscious of it. You're not aware of it. You don't have control over your own body. But if you have control over your own body and you decide to do something, you throw your fist out at someone, it doesn't matter whether you intended just to scare them. It doesn't matter if you intended, to actually harm them. None of that matters. All that matters is that you actually intended to throw your fist out there. So that's my response to people saying that like he didn't actually intend an assault.
Yeah, I mean, he got on top of Floyd. He got on top of Floyd somehow. Was it because accident? Did he trip and fall? Was it because of some sort of mistake? He didn't know that was what he was doing at the time because I don't know reasons. He was somehow unaware of that. Was it because of some involuntary movement? Was it because of coercion or duress in some way?
Mm-hmm.
Or was it because, that was what I was trying to do at the time? Yeah, I think he was trying to be on the top of Floyd. You're there. You have that general intent to do the act. You're there.
And the last issue, it was after the general intent, it was that that Chauvin, we did the causation. Chauvin didn't intend, and there was one more about Chauvin. I was just on the tip of my tongue, but there was one more reasonable doubt issue that would bring what up, but I just can't remember it now. But for those of you, if you guys remember like any other reasonable doubt issues, let us know. But most of the time, I always keep telling people too, reasonable doubt isn't just any doubt.
There was the justification aspect.
Oh yes. That's the one. That was the last one. The fact that the technique was in the training materials. But I keep telling people, just because something's in the book doesn't mean you're able to use it, especially in law enforcement. Right. It's about what you're trained to do. So when you have the trainers come up and say, we didn't train them to do that. That's in the book. For instance, on my job, there were some officers who were unarmed, and we had officers who were armed. So just because we had in the training manual, the same training manual for all of us said, this is what you do if you were armed. Those officers can't just go get their own guns and say, hey, it's in the training manual. We're going to use the guns, right? I mean, because, and the first thing John's going to say, well, we didn't train you how to use the gun, right? You have to be trained by us. You can't use your own gun. And that's the same thing here, where even if it's in the training material, as soon as the trainers get on and say, we don't train them to do that, then you're outside the box, even if it's in the training materials. And the second thing about it, too, is that you just had all those trainers testify that's not how they train you to do it, right? This was not that. So you got the trainers, and this is where cumulative gets fun. You have the chief of the department, the head of the detectives. You got the training officer, the chief of the training officer, use of force. You got like 10 people saying from that department, this is not what we do. How else who's the jury going to believe? The one expert witness that's not from their department, who's retired for 20 years, do they believe him? Or do they believe the whole Minnesota, everybody in that police department? That's where I'm talking about. So I don't think that's reasonable doubt that they had one expert from another district who's retired say that he believes is good. I think you have all versus the entire police force saying it wasn't.
Right.
So go ahead, Aaliyah.
I was going to say that another criticism I think that some other commentators have had about it is that there's also this belief that the only reason why the jury came to this conclusion was because they were afraid for their own safety because of protests and all that kind of stuff. And I think that is something that we can definitely talk about, because I think that that's something that could be a factor. And I know that during voir dire, when they did talk to potential jurors, that was something that came up quite a bit, and there's a question of whether or not the judge should have sequestered from the beginning. I know that Eric Nelson, the defense attorney, requested so many times. I mean, it was like every other day, it seemed like he was requesting sequestration. But I know that's a possible factor. But I mean, unless some juror comes out and says, this is why I came to the decision that I did. I mean, we really can't just try to, assume that in their heads. We can't assume that they were all just buckling under fear. So
no, I agree. I think if it came out the other way, they would be saying they'd be calling them heroes. It's just the nature of the jury system. But
yeah,
I always find it interesting that when you have these high profile cases like Trayvon Martin that came out the other way, right? It's okay when the jury comes out the way that I think some people like. They'll say the jury is a brave jury. When they come out the way they don't like, the jury is corrupt. It's just the way the game is always played. OJ, right? You got people on one side who are going to say they're the greatest jury on the planet. The other one that said the jury is paid off because they're all racist. So, right. Unfortunately, you got to take this. This jury had, more whites. I think they only had 4 blacks, 7 whites, and I think 1 mixed race.
I thought it was an interesting thing that the jury foreman turned out to be a white man. I just took note of that. When I looked it up, who's juror number 17, it turned out to be a white guy, who's an auditor in his profession. I thought that was interesting.
And let's not forget too, people fail to realize this was they just had to prove a simple assault. Watching that video is an assault, right? It's like the jury went back there and was like, was this an assault? Who thinks this was an assault? Yeah. After you get to your assault, you're more or less deal with everything else, right?
Yeah.
After you get to this an assault, then okay, let's just run the table right now. Let me get this. Thoughts on the cases where people have come at cops or others with knives and not got shot, although going along racial lines as a statistic. Also, why was a girl getting jumped?
Who cares?
Blah, 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 blah. And what about stand your ground laws? Okay, so there's a lot to unpack here. Other cases with people coming at people with knives, every case is different. This case, she was literally had some knife about to push it into somebody's body.
What is this second question? Maybe she deserved it. Maybe she had it coming. What is this second question?
Yeah, I don't get this. No, and then you get this whole stand your ground thing. They were on a public street, right? And the one with the knife was charging at the one without the knife. So if you're talking about stand your ground, the one in pink, the one that was getting that the knife was coming toward, she had the right to stand her ground. The person who's coming at her with the knife was not the one who's like, I can stab you and I'm standing my ground. No, that doesn't happen that way.
Stand your ground has nothing to do with this.
Yeah, and the castle doctrine stops when we're in a public street. It's like when they were in the house, that's castle doctrine. We're in a public street and you're coming out with a kitchen knife. Castle doctrine doesn't work anymore. So, I don't know where people are getting all these crazy theories. Go ahead, Alita.
No, I wanted to see that first part of the question again.
I'll bring it back up. Sorry.
Yeah. So thoughts on cases. I mean, so one thing that I was going to say is that, so just because I'm sure there are plenty of other cases where cops did not use their gun on someone that was charging at them with a knife. It's totally possible, but that doesn't necessarily mean that it's unjustified if they do use their gun in that situation. If they have a reasonable belief that this person is a danger to themselves or to other people, they have the ability to use lethal force if the threat is high enough, is lethal enough. So
the other thing I would say is that, like all these things, it tends to be so fact specific in the individual instance. I'm not sure I'm not necessarily sure it's obvious that you can aggregate them all and make conclusions about statistical differences. So I'm not sure if it's possible or not. And I'm not a statistician, so someone else would have to answer this question. I'm not sure if it's possible or not to like add up all the instances where like a white guy was charging an officer with a knife versus a black guy charging an officer with a knife, and see, well, this percentage of time the white guy was shot, this percentage of time the black guy was shot. There's a difference there. I'm not sure if it's possible because the individual issues are so idiosyncratic. I don't know if you can aggregate them like that or not.
I totally agree. I don't, to be, I'm just going to be clear. That shoot seems like a damn good shoot to me. I just, unless you convince me otherwise, even if it was a nail file, that's a knife looking nail file. You know what I'm saying? And it's almost like suicide by cop at that point,
I just think it's so telling that the girl in pink hasn't made any statement, because I think she's, I mean, I would, if I had to speculate, I would imagine that she doesn't want to say, I'm so glad the officer saved
Thank
my
God
life.
for that.
That's not necessarily the most tenable thing she wants to say right now. I don't know.
I think I saw in the comments earlier that someone said that she had made a statement, but I don't know. I haven't seen anything about that. But
how could we have Chauvin? How could have Chauvin acted differently to have not been convicted? I think this will help people understand what he did was wrong. Okay, well, number one, when they started checking the polls and saying we find no polls, that's when you start turning from an arrest to maybe this person is in need of medical attention.
right.
And when other officers are saying maybe we should turn him around, he's passed out, he's not breathing.
Right.
Those things would, a reasonable officer would say, let's check him out. Let's make sure he's still okay. What do you guys think?
I 100% agree. I think that once he, I mean, and here's something too, is that, when the officers are on top of him, obviously they can feel him struggling, right?
Mm-hmm.
So they can tell when he's no longer struggling. So I think that at that point, if they, if they sense that, they can also check to see if he's breathing, if he's conscious. And at that point, then turn him over to his side, maybe let off some of the pressure. He's already handcuffed, for example, so it's incredibly difficult for him to get away in that situation if he's handcuffed, and if they're still watching him, and they can have some pressure, but maybe not as much pressure.
Yeah, no, definitely. Oh, Nate knows both sides of the seesaw. Oh yes. Because again, unfortunately, each one of these cases is just so different, and you can't, if you think it's a cookie cutter approach, it just can't be, because the facts it's still driven by the facts. To me, it's a tragedy. No killing is good, in my opinion. Of course,
Agreed.
Yeah, but the thing is that what we try to figure out is whether it's lawful or not. It's our issue isn't the killing; it's whether it's the law allows it or not. And obviously, we don't believe Chauvin was it. I honestly am flabbergasted that anyone disagrees with the Columbus shooting. Someone was about to get stabbed. Yeah, facts. Like stabbing with a for real knife. Yeah, but you know what though? We live in America, and right now it's not popular to be police. It's not popular to use force, and it's not popular to seem to save lives. So I think this young woman should be happy that this cop didn't allow her to get stabbed. But it's a shame when we stop looking at the incident and start looking at people's races, right? Like, hold on, instead of what happened and why did we get here, to who did it? Is it white cop, black guy? Okay, let's start marching in the streets. That's not the world we should.
Race was never mentioned in the Chauvin trial, except for the very end, for the inherent bias instruction, which is just pro forma.
Yeah.
But the prosecution never mentioned race. The defense never mentioned race. Race never came up in the Chauvin trial.
Yeah, well, I think the race issue was something more nationally, and just for the fabric of America. I think if you're just talking about, because obviously this just kicked off the Black Lives Matter movement, but I think there's a difference. I think when I talk to conservatives and liberals about this issue about race, they're talking out of two different. They're talking about two different things. When you're talking to a liberal, they're talking about 1950 Jim Crow. We're back there, right? And when you talk to a conservative, they're in a utopian society where race is not a factor. We're all equal and there's no racism. That's just not true too. And I think that's where if we both have if we're both so far apart, how do we get to where we're actually at right now, right? I don't have to suffer as much oppression as my grandfather did, but it's still not as equal as we would like it to be. And I think on one end, we have to respect the fact that we have come far. You know, America, we just had a black president, for God's sake. We've come very far as Americans, but we also have to understand we still have a ways to go. And I think if we get to that point, then we'll be okay. But right now, we're not there. Right now, it's war. Like, you know, it's you're left or right, or that's it. So
yeah.
Go ahead, Alita. I'm sorry.
I mean, I completely agree. I absolutely completely agree with everything that you just said. And I think that, I mean, I often think about, you know, the two political sides as sort of in the same way that I think of two lawyers advocating for a plaintiff or a defendant. You know, it's like they have a particular role that they're taking. They're advocating for a certain side, for a certain client, you know, and whether or not they actually believe in what it is that they're advocating sometimes is it can be fun to find out. But I think that, you know, when it comes to the two political sides, it's like sometimes it can get to be very extreme on either side. And it's so frustrating because that's obviously not where we're going to find resolution, right? But I mean, at the same time, I also kind of understand from an objective standpoint why both sides sort of take on this sort of advocacy role that is a little bit more extreme than what most people actually probably think, because they're trying to increase the sort of force that they have in order to make a difference in the world that they think it should be, if that makes sense.
Yeah, it does. Well, listen, we have been at this thing for about an hour and a half. Uncivil Law doesn't look drunk enough. Alita is just waking up, and I am tired.
I don't have to drink all the time.
Oh my god! Oh my god! Well, the Katie Joy case we draw, and the streak continues too. I just want to make everybody know the streak continues. The streak continues. So, at the end of the day, the streak gets yes. So check this out. So next week we are going to be on Uncivil Law's channel, same bat time, 9 o'clock Wednesday. We'd love all of you to join us. We're always going to talk about the new hot topics. Uncivil Law likes to go into the constitutional law of it all. So I know he's going to have some great stuff for us to talk about next week. Hold on. This was one last super chat. Again, this is going to be the last super chat of the day, guys, because we're about to get out of here. Was Chauvin trained to keep his knee on a handcuffed person's neck? I don't understand that. No, because the prone position I was just so everyone understands my training. I was actually a handcuffing instructor for law enforcement. I was certified. I taught defensive tactics, handcuffing, and aspeton training. And no, the prone position is a transitional position. You put the cuffs on, you put them in the recovery position, and you keep it moving. They don't train you to keep you on top of somebody like that. So that's what I train. But again, that's in New York. I'm not sure what they trained in Minnesota, but generally, no, that's not it. So don't forget to check out Legal Bites. We'll be there in 2 weeks, right? 2 weeks we'll be on Legal Bites channel again.
Yes.
Next week we will be with Kurt. Hopefully you guys enjoyed this, and you know, be kind to each other. We got like another week of hell. Hopefully it won't be that crazy. And let me let Kurt and Alita tell you what's coming up on their channels. Alita, what's coming up on your channel? What can the people expect?
I'm actually going to do probably another video or two on the Chauvin trial. I know it's a little bit late since it's been over 24 hours since the verdict came out, but I want to do kind of like a rounded out analysis of the charges and kind of how the jury came to that conclusion and whatnot. So yeah, go on and check it out there. If you can't get enough, if you haven't had enough of the Chauvin trial already.
Go ahead, Kurt. What you got coming up on the channel?
I was just looking through the list of all my stories that's ready for me to post, and I think I need a fun one tomorrow. So I think tomorrow's story is going to be whether or not Pastafarianism and belief in the flying spaghetti monster qualifies as a religion for Religious Restoration Act purposes in federal penitentiaries.
Oh, so that's fun.
We're going to determine if federal prisoners are entitled to believe in the touching of the noodly appendage. That should be great.
That is fun. That is fun. I used to look at cases like that when I interned for the California Attorney General's office back when Vice President Harris was the California Attorney General, and I was in the correctional law section. And so it was which meant that we were defending the state of California against all kinds of claims by incarcerated people primarily men. And it was like all kinds of crazy claims, but a lot of them were like religious liberty claims. So I had to analyze that kind of stuff. I mean, some of these cases were just, they were wild. I literally, they would handwrite them, the complaints themselves. And I remember one time I actually had to literally print out a complaint that was handwritten, cut it out into many pieces, and then puzzle it back together, literally cut and paste together, just so that I could understand it. But so yeah, anyway, that's a total digression, but yes, that should be a really interesting video, Kurt.
So now you guys know where to go for some more good, interesting legal topics. Don't forget, next week on Civil Laws Channel, 9 o'clock Wednesdays, 2 weeks from now, Legal Bites, 2 weeks from today, 9 o'clock. We will see you guys, same back time, same back channel. My name is Nate the Lawyer. I'm about to crash and fall asleep, but for Uncivil Law and Legal